What if the government had no legal right to tax you? Not a loophole, not a gray area buried in legislation, a verdict, delivered by the highest court in the land. In 1895, that is exactly what happened, and the shockwave it sent through American democracy did not stop for 17 years. This is the story most Americans were never taught. A story about obscene wealth, judicial power, and one of the most calculated legal ambushes in United States history. This is Pollock versus Farmers Loan and Trust Company. To understand what broke in 1895, you have to feel the America that existed just before it. Picture a nation of impossible extremes. The Vanderbilt family had just completed the Breakers, a 70-room summer cottage in Newport, Rhode Island. Marble imported from Italy. Chandeliers worth more than most Americans would earn in a lifetime. This was not extraordinary. This was Tuesday for the Gilded Age elite. Carnegie controlled steel. Rockefeller controlled oil. The railroad barons controlled movement itself. These men did not merely participate in the American economy. They were the American economy, and the system protected them completely. The federal government funded itself through tariffs, taxes on imported goods that quietly extracted money from ordinary consumers at every turn. The wealthy, whose fortunes flowed from property, dividends, and interest, moved through this system almost entirely untouched. Then came 1893. The panic arrived without mercy. Banks collapsed in waves. Unemployment surged past 17%. Families who had built stable lives found themselves in breadlines, watching everything disappear. Congress felt the pressure, and in 1894, it moved. The Wilson-Gorman Tariff Act introduced a 2% federal income tax, applied only to the top earners. The working class would pay nothing. Only those at the very peak of American wealth would contribute. It was modest, it was targeted, and to the men at the top, it was a declaration of war. His name was Charles Pollock, an ordinary shareholder, a face in the crowd with no particular claim to historical significance. But Pollock was not the architect of what came next. He was the mask worn by those who were. Behind him stood a coordinated network of elite corporate attorneys, men who understood constitutional law not as a shield for citizens, but as a precision instrument that, wielded correctly, could dismantle any legislation threatening the fortunes of the American ruling class. Their argument was surgical. The Constitution demanded that direct taxes be apportioned among the states by population. Income from property, dividends, rents, and interest payments was precisely such a tax. And the Wilson-Gorman income tax apportioned nothing, which meant Congress had passed an unconstitutional law. The Supreme Court heard the arguments, and in the spring of 1895, it ruled. 5 justices against 4. The income tax was unconstitutional. Justice Stephen Field went further than the ruling required. He warned, in words that chilled reformers across the nation, that taxing the wealthy was the opening shot in a war of the classes. In a single ruling, the government's ability to fund itself fairly had been legally destroyed. The fallout was immediate and severe. Washington retreated into full dependence on the old broken system, tariffs and excise taxes that punished consumers while the wealthiest Americans continued to accumulate, untouched and legally protected. But this was more than fiscal inconvenience. It was a structural crisis at the worst possible moment. The world was changing rapidly. European powers were expanding their militaries. Global trade was reshaping which nations held real power. America stood on the threshold of becoming a world power, and it could not fund the infrastructure, the military capacity, or the institutions that required it. Not because Congress lacked the will, because the Supreme Court had placed the mechanism for doing so beyond constitutional reach, and the public noticed. What grew in the years following was not merely frustration. It was a corrosive suspicion that the Supreme Court had made itself the permanent legal guardian of the ultra-wealthy, that the Constitution had become not a framework for democratic governance, but a fortress wall protecting privilege from accountability. The system was not broken. It was working exactly as designed for someone else. 17 years. That is the distance between the court's ruling and the constitutional correction that reversed it. The reformers who refused to accept 1895 understood one thing clearly. Legislation could be struck down, court arguments could be lost, but a constitutional amendment stood beyond the reach of any judicial ruling. It was the ultimate override. The people speaking above the court. The coalition that formed was unlikely by any measure. Populists, progressive Republicans, labor leaders, Democrats, and, remarkably, President William Howard Taft, a conservative who would later become Chief Justice of the very court that had blocked the tax. In 1909, Taft threw his full support behind a constitutional amendment authorizing income taxes without apportionment. The amendment went to the states. Corporate lobbyists spent fortunes trying to stop it. But the progressive era had arrived in full force, and populist pressure in state after state overwhelmed the resistance. On February 3, 1913, the 16th Amendment was ratified. Congress shall have power to lay and collect taxes on incomes from whatever source derived. 32 words, 17 years in the making. The wall was down. What followed changed everything. The 16th Amendment funded 2 world wars. It made the New Deal possible. It built the highways, hospitals, and military that defined the American century. The modern United States, in all its complexity and power, is materially impossible without the revenue system that amendment created. But here is what makes Pollock more than history. The questions it raised have never been fully answered. In 2025, debates over wealth taxes and billionaire loopholes move through Congress and immediately face constitutional challenges from teams of elite attorneys using arguments that echo, almost word for word, the reasoning that prevailed in 1895. The distance between the wealthiest Americans and everyone else has returned, by nearly every measure, to Gilded Age proportions. The 16th Amendment settled whether Congress could tax income. It was never settled whether it does so fairly. And the friction between the judiciary and the Treasury, between what courts permit and what democratic majorities demand, continues to shape the balance of power in the American Republic today. One Supreme Court case shattered the government's ability to fund itself. One constitutional amendment rebuilt it. And the argument underneath both, about who bears the burden of sustaining a nation, about whether law serves power or constrains it, that argument is still being made. In courtrooms, in legislatures, in the space between what the law says and what justice requires. The Gilded Age never truly ended. It simply learned to speak the language of constitutional law.